Hi, everyone. Thanks for tuning in. This is the JQK Immigration Law Firm. I'm John Kasravi, immigration lawyer, here with my wonderful associate, Anis Sergiva. We're going to talk about top 5 mistakes people make in filing Form I-130 petitions. These are petitions from family members of U.S. citizens or green card holders for getting green cards for their foreign family members. In some major ones, we see that become a big headache and cause massive delays for people, and we really want to avoid that. So the first one is something interesting we see every once in a while. It's about designation of where your case is going to happen. So Anya, can you talk about what mistake people are making on Form I-130 with this designation?
Yes, so on a form I-130 specifically asks if you're gonna adjust your status in the United States later on, right? Or you're gonna go through the consular process and get your immigrant visa at the U.S. Embassy. And
Mhm.
this is very important. Sometimes people come to us, right, with the petitions that they already filed, and they just mess these things up. So it's very important to decide which route you're gonna go, right? If
Yeah.
you are in the United States, probably, for example, if it's immediate relative petition, right, you submit together a Form I-130 and a form for adjustment of status I-485. And under these circumstances, you mark yes, we will be adjusting status in the United States, and you name the office, USCIS office, where you live. How to check this out? Or USCIS website, you can go and just Google USCIS office locator. You just enter your zip code there, and the office that you belong to will pop up, and you just put this office in this petition. If you are outside of the United States and you're filing a I-130 petition, for example, for your parents, for your sister, for your brother, and so on, right? They will go through the consular process, right? And on the same page, but next to it, you would mark the U.S. Embassy, the country, the city and province where the U.S. Embassy is located, where you're gonna consular process. The important thing about it is that you cannot pick and choose the embassy where you're gonna be consular processing. Usually, you have to live lawfully reside in this country. You might be a citizen of other country, but you, for example, you can be a citizen of I would say, I don't know, Netherlands, right, and live, for example, in Turkey. So under
Yeah.
these conditions, you would have your interview in Turkey because you reside in there, but you have to show proof that you're a resident in this country.
Yeah, and the mistake people make is when we have a case right now we're working on where they did the I-130 petition. They said they're going to do. They marked actually both adjustment of status in their local field office and the embassy. And USCIS decided, oh, this is an adjustment of status case, and they kept the case in the U.S. So now the client has to go and file Form I-24 to request the case be sent to the embassy, and this is going to add 3 months to a year and a half potentially of delays with Form I-24 to send it. It's a nightmare, extra cost, delays from loved ones. And it could have been just as easy as just marking consular processing and leaving it blank or not right, not applicable for the adjustment of status. Now, there's the vice versa where people mark consular processing and then they come to the United States on a B2, for example, and then they change their mind and decide to stay here. In that method, you file Form I-485 and it just works out. You don't have to file I-24 additional work necessarily. But if you're going to start the case in the U.S., but it's really supposed to be the embassy, it's a major headache to fix that up. And that's why this is the first one I want to talk about, because when it does go wrong, it goes really bad. Now, a side note, if you do decide to file for adjustment of status in the cases with the National Visa Center, State Department, Consular Processing, you do want to notify them that we are going to do adjustment of status, because sometimes the Department of State and the NVC will delete a case or just if there's no movement on it after a year. So a lot of mess ups happen, and that's where the point of immigration or comes in, is just to kind of watch out for all these things that are really unexpected. You wouldn't think would happen, but they do. We see it frequently enough. So the next thing we wanted to talk about is separate petitions for immediate relatives. So this is a really confusing aspect of the I-130 process when you're filing for a family member. If you're a U.S. citizen and you're filing for what's called an immediate relative, this is a parent, a spouse, or children. The one I-130 has to be made for each one. So if you want to bring your parents, for example, you need two Form I-130s, one for one parent and one for the other. If you want to bring your spouse and kids in, and the kids for some reason don't have citizenship or green card already, you file one for the spouse, and then each one separately, separate I-130 for the children. There's all these extra fees that come into play. On the other side, if you're a green card holder, you can't file for your parents, but if you file for your spouse, the children automatically come within it. And when you're a U.S. citizen and you file for like a brother and sister, those children automatically come in. And we'll talk more about this later. But the main point I wanted to make is we have issues where people, they marry somebody and then they have stepchildren, for example, that are young, and they just file one I-130 for the spouse, gets approved, and then they're like, well, how come we're not getting consular processing notifications for the children? That's because the children they don't have a separate petition when they're supposed to, and then you have to wait another 8-10 months for the child to get approved, and it's really destructive for the family relationship to be waiting all this kind of stuff. So it's very important for people to know they differentiate. And the reason why they do that is when you're a U.S. citizen, and you file for immediate relatives. There's no extra wait in line. There's no limitations per year of how many people could do it. And so that's why they don't have group aspects for this. They say one person at a time to limit the number because there's not that extra weight that, for example, a spouse of a green card holder may have. As we're recording this, there's no extra line, but it does pop up where they might have an extra year or two because of the backlogs. It gets a little complex. So the next thing I wanted to talk about is the documentation we send with the I-130 and some mess ups people have that creates more work for them. Anya, can you talk about that?
Right. So this is very important not to send with your petition your original documents. It's in the instructions, but a lot of people, they don't read the instructions and they send their original, for example, marriage certificate or birth certificate, right? And that's it, it's gone. And for example, if it's consular processing case, when one goes to the interview, for example, for immigrant visa, right? You need to bring almost all originals of the paperwork that you submitted to USCIS, right? But you already submitted it to USCIS and you don't have it on your hand, and it can become a very big problem too. So please be aware, don't submit original documents.
Yeah, photocopies are fine. Now, rarely they may ask you to mail in original, but it's almost never done. You bring the originals to the interview, even if you're doing adjustment of status, consular processing, you bring it to the interview, they compare the copy with the original. That's it. So don't send birth certificates, marriage certificates. Many times it's very difficult to get a new one. It's a big mistake. Now, USCIS does have a particular form to make a request for original documents to be returned, but that's extra work. You don't know if it's going to return, even if you submit it, or how long it'll take. And it'll create disruptions down the line because you might need to bring the original for consular processing. You might need it for school records or something like that. You might need it for your life. So the last thing you want to do is send original documents. It's not a requirement. And many people think it is, and they give away these documents and have a big headache trying to get it. Right. So the next thing is the domicile requirement that comes into play in the I-130s. Now, you always have to be truthful of what your address and residence is with any immigration application. But if you are doing any case, in particular through consular processing on a family-based I-130 petition, the petitioner, the U.S. person, whether a green card holder or citizen, has to be quote-unquote domiciled in the United States. Now, the domicile requirement was written in an act by Immigration Nationality Act. It's not very descriptive. It's a very short paragraph or two on what that means. But essentially, they want you to be living in the United States. So let's say I want to apply for my spouse, and I'm living in Bulgaria, for example. They could deny my case later on at the embassy stage, saying I'm not domiciled in the United States. And how they'll know that is they'll see my address history in the I-130. And then later on, for the affidavit of support, they'll see it. So you really want to have your addresses correct. For example, if you live in the U.S., but you're spending a lot of vacation time with your spouse overseas, keep coming back and forth, they say you spent 3 months there on vacation. That's still a vacation. But if you have your house here, potentially work and stuff, you're still considered residing here. So be careful, because if you list on the I-130 you have a foreign address, but you're not really living abroad, later on they can use it and say, well, domicile requirement shows proof you're actually living in the United States. And that becomes a hurdle because there's more procedural work you have to do. Now, in the regulations for the Domicile Act, they say that even if you are living overseas, you could potentially tell the embassy officer that I'm going to move with my spouse or the family member to the United States upon getting the immigrant visa. That is in the regulations. But just because somebody's in the regulations and the laws doesn't mean they're actually going to prove it. So I've had cases in some countries where they'll say, okay, if you're moving with your spouse, it's all good. We'll give the green card. You guys move together. And I have other countries that say, well, move back to the United States, show me a lease agreement or home purchase, show me your work, show me voting records, show me this and that. And then once I believe you actually move back and we're domiciled in the United States, then I'll adjudicate the visa. and all of a sudden you got to go rent a place, and you got to do this and that. And so you got to be really mindful of this requirement, because I-130 is the first spot they'll see your residential history that's going to get you on this. Now you have to, again, be honest with it, but you got to sometimes know what's going on and make a decision to stay in the United States, your life here, so the domicile requirement won't be a problem later. But sometimes you may need to be living with spouse overseas. You don't want to be alone. Just know that for consular processing, you're going to have to deal with this hurdle one way or another, but it's important to know from the very beginning. And finally, last one, Anya, eligibility relationships. What relationships can you file the I-130 for, and some nuances that might not be expected?
Right. So you can, if you're a U.S. citizen, right, you can file for your spouse, for your parents, for your brothers and sisters, and for your children, married
Both
or unmarried.
adult and minor, even whether
Yes.
they're married or not.
Correct. If you're a lawful permanent resident, you can't file for your sisters. You can't file for your parents. You can file for your spouse, right, and
Yeah.
minor children.
Yeah. And adult children if they're unmarried. And so we have this problem. I had one case where Kai contacted me where the father was a green card holder, filed for a single child, and then the father was getting his interview for citizenship. And if he became a citizen, if the child was married, it'd be okay. But a week before the father became a citizen, the guy went and got married. And so by getting married, it destroyed the green card holder case based on being adult child of a green card holder and being single. Whereas if he waited an additional week to get married and the dad had became a citizen, then that would have been okay. So it's really wild. And then there's other situations where there's step-parent relationships. For example, if you're a U.S. citizen, you marry someone's mother, and the child that someone is like 14, 15, under the age of 18. They come in and could be a step-parent and do an I-130 petition for that. So that's really important. And sometimes people are deciding to get married. That's one reason to rush the marriage before the child turns 18. If you're getting married anyways, those are the plans, to get them in. And there's adoption, where adoption has to be completed before age of 16. So that's a little more nuanced. And there's another issue. Sometimes you have parents that never got married. And, the mother could always file an I-130 if they're a citizen or green card holder for the child. But there's more stringent requirements many times for the father if you're not married, if it's out of wedlock marriage. And so for those, many times they'll say, well, prove to us, even if the parents are not married, that the father was in the child's life. Show receipts of paying money, sending money to them. Show school records where they're listed as the person that come and pick them up from school, or show that they're traveling to see the child, they're in the child's lives, to prove that a parent-child relationship existed, even though the parents weren't married. And that gets different levels of complexity. Many times they don't have documentation. Nowadays with email and stuff, there's not more ways of getting documents. But if you're 1980, 1990, early 2000s, we don't have as much digital documentation. It becomes much harder to prove this type of relationship existed. So something very mindful of when you're thinking about doing these I-130s.
Yeah, so please be mindful of immigration planning. There's such a thing, because anything you do can cause problems. Or as John just told us a story about the guy who got married 10 days before he got naturalized, right? And he destroyed the case. So he probably didn't know about these requirements, right? But again, that's where immigration attorney comes in, right, and help you. Not to do
me and show the docs like, what's going on in my case? And I'm looking at the dates. I'm like, are you serious? You got married a week before you filed a citizen? You couldn't wait a week? And they didn't know. So it was so heartbreaking having a conversation with them, because it's just like, oh, you just messed it up. Because now they have to go and redo an I-130 as an adult married child of a U.S. citizen. And that's how many years of waiting.
And he goes to the back of the line, right?
Back of the line, complete new line at the back. And then just waiting and waiting, whereas they probably would have had the green card by now if they had kept that original case alive. And a lot of people don't expect cases to get canceled out like that, but it just happens. So be very, very careful of that. It just, not everyone's going to be filing this kind of case, but for those who do, it hits really hard if they don't do it right. So we want to share this information. If you are interested in learning more and talking about your case, just email us at info@jqqlaw.com. We'll set up a video consultation. We always do our consultation by video so we can see you and really, as a human-to-human contact. The phone alone, unless you don't have access to video, which almost everyone does nowadays, you can even pull up WhatsApp or Zoom or whatever is necessary. But just a human connection. We'll do a video consultation and break it down. There are fees for consultations, but email us, let us know what kind of case you have, and we'll break it down if we could do it, or if we could set a talk, or whatever is necessary. We'll be there for you to take it next level. Thank you, Anya, so much for going over the top 5 mistakes we've seen for I-130 petitions.
Thank you all. If you like this video, please like it, subscribe to our channel, and see you in the next time.
Very important point. Thank you so much. See you all next time.